Welcome to the Pennsylvania Case Law Update While You Drive podcast. You give us less than 20 minutes per week, we will make sure you never miss changes in the law. This week's episode is brought to you by the McShane Firm. For nearly 20 years, the attorneys of the McShane Firm have been trusted by our neighbors and our friends to represent them in DUI and criminal law cases.
Thank you for joining us for another week of the Pennsylvania Case Law Update While You Drive podcast. I'm your host, Katie McShane, and this is episode 7. Today, we cover cases decided between July 29th, 2020 and August 4th, 2020. We will begin with a couple criminal law cases. The case of Commonwealth v. Byrd addresses the mutual consent exception to the Wiretap Act. In this case, appellant Byrd was incarcerated. During his incarceration, Dana Heaps visited him. Visitation was conducted through a closed-circuit system where appellant was on one side of a partition and the visitor is on the other side, and they communicate with a telephone-like handset. Each time they lift the handset, a recording stating, "This call may be monitored or recorded," is played before the parties can begin speaking. During one of the visits, the two discussed an assault that the appellant had committed against Heaps. The appellant was later charged for that assault, and the prosecution sought to enter the recorded jail visit calls as evidence, and the appellant filed a motion to suppress to keep them out, claiming that they violated the Wiretap Act because he didn't have actual knowledge that he was being recorded. In general, the Wiretap Act prohibits the interception, disclosure, or use of any wire, electronic, or oral communication. The mutual consent exception states that it shall not be unlawful and no prior court approval shall be required for a person to intercept a wire, electronic, or oral communication where all parties to the communication have given prior consent to such interception. In deciding the case, the Supreme Court found that actual knowledge is not required and that prior consent under the mutual consent exception is based on whether an individual knew or should have known they were being recorded. Because the recording alerting the participants that the call may be monitored or recorded is sufficient to put a reasonably intelligent person on notice that he was being recorded. In the criminal case of Commonwealth v. Distefano, the issue before the court revolves around the admissibility of cause of death evidence when the homicide charges were previously dismissed. In this case, the defendant and victim were walking home from a party together. They were both intoxicated at the time. A third person was walking with them but was walking about 10 feet in front. The third person heard the defendant and victim arguing, and then a few moments later heard more of a scuffle and saw victim on the ground with the defendant on top of him with defendant's hand near the victim's chest or neck. The third person said the defendant couldn't have been on top of the victim for more than 5 or 6 seconds. The victim was still breathing at that time but was unconscious. The victim was rushed to the emergency room but was soon after pronounced dead. The defendant was charged with homicide and aggravated assault. The homicide charges were dismissed because the court found that there was insufficient evidence connecting the defendant's actions to the victim's death. The defendant then filed a motion to suppress evidence of the cause of death as irrelevant and unduly prejudicial. The trial court granted the motion and the Commonwealth appealed. The Superior Court found that the testimony regarding manner of death was permissible, even though the opinion of the pathologist was inconclusive. The weight of the evidence, meaning how much the jury relies on that evidence, is up to the jury to decide. Up next is an insurance case. Franks v. State Farm Mutual Automobile addresses whether or not a stacking waiver is required when a vehicle is removed from an insurance policy. The court is evaluating the Motor Vehicle Financial Responsibility Law, the MVFRL. In this case, the Franks initially had 2 vehicles on the policy. When they purchased that coverage, they signed a stacking waiver for purposes of underinsured or uninsured motorist coverage. Stacked insurance coverage allows you to recover more per accident when you have multiple vehicles. For instance, if the uninsured motorist coverage is $100,000 and you have 2 cars on the policy, you could recover $200,000. When you waive stacking, the benefit is that you pay a lower premium. They later added a 3rd vehicle to the policy and again signed a stacking waiver. Subsequently, they removed a car from the policy and at that time no stacking waiver was signed. The court first held that the MVFRL should be construed always in favor of the insured. In light of this, the court ruled that a stacking waiver was required every time there was a change in coverage, not just a new purchase. The next area of law today is property law. In the property case of Joos v. Board of Supervision of Charlestown Township, the court analyzes the decision by the Board of Supervisors imposing a condition prohibiting any future driveway to a plot line revision plan. The court analyzed the Municipalities Planning Code, or the MPC, which authorizes a municipality to regulate the subdivision and development of land by ordinance, as well as the Charlestown Township Subdivision and Land Development Ordinance, or SALDO. The court ultimately held that the appropriate remedy for addressing future concerns about the driveway is the permitting process. They found that the Board of Supervisors exceeded their authority by imposing the driveway condition in the revision plan. They found that the condition was not appropriate to effectuate compliance with relevant statutes and ordinances or reasonable in order to make the plan be in compliance. The Joos also requested contempt to be filed against the Board of Supervisors because they failed to respond in a timely manner. To establish contempt, the complainant must prove that the contemnor had notice of the specific order or decree which he is alleged to have disobeyed, that the act constituting the contemnor's violations was volitional, and that the contemnor acted with wrongful intent. The court found that the trial court did not abuse its discretion in denying the petition for contempt. We'll be right back after a brief note from our sponsors.
This segment of Pennsylvania Case Law While You Drive podcast is sponsored by the McShane Firm. The McShane Firm is Pennsylvania's largest and best DUI and criminal law firm. Their mission is simple: make sure the presumed to be innocent remain innocent.
Welcome back. We have two cases discussing protection from abuse orders this week. Diaz versus Nabiyev is an appeal from a permanent protection from abuse order. In this case, Diaz and Nabiyev met through a dating website. They eventually moved in together and got married. They were married in a religious ceremony but did not enter into a legally recognized marriage. Shortly after, the relationship deteriorated. In December 2018, the victim rejected the appellant's sexual advances and she tried to leave the house. The appellant grabbed her, refused to let her leave, and threatened to kill her if she ever left him. In May of 2019, the victim suffered a miscarriage and the appellant learned that she was legally married still to someone else. The relationship further deteriorated. Again, in May 2019, the victim sought a final paper from the church to formalize their separation. The appellant showed up at the mosque, grabbing her clothing, shouted obscenities at her, and threatened to ruin her life. In September of 2019, the appellant showed up at the victim's work. When the victim left, the appellant followed her, again yelling obscenities and threatening to kill her. The victim filed for the protection from abuse order immediately after this incident. In this case, the appellant claimed that because the incidents that the victim said caused her to be in imminent fear of bodily injury happened a long time before she filed for the protection from abuse order, the court erred in finding that she was in imminent fear. The Superior Court upheld the order of the PFA court and found that there was sufficient evidence to establish that the appellant knowingly engaged in a course of conduct toward the victim that caused her to be in reasonable fear of bodily injury. In the case of B.R.S. versus J.L., the court addresses whether a petitioner has standing to seek a protection from abuse order against his wife's sister's husband. Here, the victim was eating lunch at a restaurant when he saw his sister-in-law, his wife's sister, come into the restaurant. Her husband was outside and stared at the victim in a stalking manner. When the victim left the restaurant, his sister-in-law's husband cursed at him, pushed him down to the ground, and punched him in the face. A protection from abuse order applies to family or household members, which has been defined as spouses or persons who have been spouses, persons living as spouses, parents and children, other persons related by consanguinity or affinity, current or former sexual or intimate partners, or persons who share biological parenthood. The court found that the only possible relationship in this case is a relation by affinity. Affinity is not specifically defined in the statute, but the court faced a similar issue in a previous case and found that affinity includes a familial relationship of brother-in-law or sister-in-law. The court found that the act should apply to all brother-in-law or sister-in-law relationships so as to give effect to the statute in a way that promotes the purpose of preventing violence among people with a domestic, familial, or romantic bond, past or present. Here, the victim did have standing to seek a protection from abuse order against his wife's sister's husband. Next up, workers' compensation. In the cases of Arlet versus Workers' Compensation Appeal Board, the court addresses who is the appropriate party to pay out workers' compensation benefits for an employee who was injured while on the job. In this case, the claimant was employed as a shipwright for Flagship Niagara League. A shipwright is like a carpenter for vessels. Most of his work is maintenance and repair and done while the ship is in port or dry dock and he does not sail with the vessel. At the time of the injury, the employer did not have workers' compensation insurance, but did have a commercial hull policy which covered injuries to members of the crew. The insurer did pay out to the claimant. At issue in this case is whether the employee is a seaman for purposes of recovery under the Jones Act. The Jones Act is a maritime law that allows seamen who are subject to the perils of the sea to sue their employer for injuries sustained during employment. The Jones Act provides the only remedy a seaman is afforded, and no remedy under the workers' compensation laws is allowed. The court determined ultimately that the claimant is neither a seaman nor a member of the crew. The term member of the crew is interchangeable with seaman, and as such, the Jones Act is not the appropriate remedy. Further, as the two are interchangeable, he should not have been eligible for benefits under the Commercial Hull Act. However, the insurer had already paid out the claim. The insurance company sought to recoup the money they paid out from the employer. However, they could not collect from the employer as the law prohibits an insurer from subrogating their own insured. Subrogating a claim means the insurance company collects money from the party which caused the loss to the insurance company. Ultimately, the court concluded that the employer should have paid, but since the insurance company had already paid the claim, the insurance company could not collect from the employer. The final area of law we will address this week is wrongful death. Reibenstein v. Barax is a wrongful death case that addresses the statute of limitations for bringing a claim. In this case, the patient died from an aortic aneurysm, which was listed as the cause of death on the death certificate. The patient's estate brought suit against Dr. Barax. Dr. Barax failed to participate in the deposition until ordered by the court to do so. Several years had passed before Dr. Barax testified. At the time of his deposition, Dr. Barax testified that he informed Dr. Conaboy of the aneurysm and explained that it was a poor picture and could not tell if it was bleeding or ruptured. Upon discovery that Dr. Barax had told Dr. Conaboy about the aneurysm, the patient's estate filed suit against Dr. Conaboy. Dr. Conaboy filed a motion for summary judgment on the grounds that the 2-year statute of limitations had expired in which to bring suit. The Act provides an exception to the 2-year time bar, allowing for equitable tolling of the time if there is an affirmative misrepresentation or fraudulent concealment of the cause of death. Dr. Conaboy argued that there was no representation because the accurate cause of death was listed on the death certificate. The estate argued that the term cause of death should not only be limited to recording the correct cause of death on the death certificate, but should encompass those acts which were part of the chain of causation leading to the patient's death. The court agreed with the estate and found that the language of the statute was ambiguous and that the legislative intent necessitated including the events which were part of the chain of causation. The court ruled that the case could proceed against Dr. Conaboy despite the fact that more than 2 years had passed. Thank you again for joining us. As always, I hope you learned something and have a little extra in your arsenal this week.
Thank you for listening to the Pennsylvania Case Law Update While You Drive podcast. Be sure to subscribe to this podcast and our YouTube channel to make sure that you are always in the know when it comes to important changes in Pennsylvania case law. We want to thank this week's sponsor, the McShane Firm. The McShane Firm is a central Pennsylvania fixture when it comes to DUI and criminal defense. The attorneys and staff at the McShane Firm believe in good old-fashioned central Pennsylvania values like hard work and straight talking. Give them a call if you or a loved one ever needs help.